The last one.
That's the last one.
Okay, here we go.
See that? Artificial self-authentication. Is that? I'm not sure.
Ready? Court does call the case of the people of the state of Michigan versus Lovely.
Buckle up. This courtroom showdown is not your average custody dispute. What starts as a simple parental exchange spirals into legal chaos, missed pickups, ignored court orders, and a mother who flat out refuses to comply with a judge's command. Judge Simpson takes the bench, and right from the beginning, we feel the tension. Attorneys on edge, a confused defendant, and a child caught in the middle. You're about to witness a real-time unraveling of trust, responsibility, and the consequences of defiance. This case involves Alante Lovely and her ex-husband Corey Johnson, embroiled in a bitter fight over shared custody. When one side breaks the agreement and skips town, the entire justice system is pulled in, from CPS to multiple police jurisdictions to circuit court orders. The result? A packed courtroom, a trooper with hard truths, and a judge who doesn't tolerate games. This is not just legal drama, it's real stakes, real law, and real consequences. Let's get into it.
Yeah, thank you, and good afternoon, Jonathan Memons on behalf of the people. And Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lovely, who stands to my right in court.
Okay, thank you. We're ready to proceed to exam.
Defense is ready. Yeah, people are ready to proceed in this matter. My understanding is that there's also some kind of a violation hearing. Did you want to do the exam and then kind of do everything all at once, or however?
Yes.
you want to proceed? Perfect.
That's
Not that there's anybody else left. I'm going to call my first witness is going to be Corey Johnson, but I have the officer in charge, Dusty Patel, also here with us today.
all right. Sir, please come forward. Be sworn. All right.
Raise your right hand for me. I swear our firm testimony you're about to give, the truth, the truth, and nothing but the truth. State your spelling for some of the record.
George, I think. Got it. All right, go. You may inquire.
Yeah, thank you. And good morning, Mr. John, or good afternoon, Mr. Johnson. Thank you for being here today. Just to kind of get right into it. With the court's permission, there's a child involved here. I'm just gonna refer to it as the child, so I'm not putting his name.
That is fine.
And likewise, if defense could. Do you have a son?
We're now entering emotionally charged territory. When a courtroom turns to questions about children, the temperature shifts. Notice how the prosecutor doesn't name the child directly, a respectful and strategic move to protect identity, but it also adds weight to the moment. The witness, Corey Johnson, confirms he shares a son with the defendant, Miss Lovely. This matters because everything that follows revolves around this child's well-being. Every missed pickup, every ignored order, every delay. It's no longer just about parental rights. It's about a child whose stability is being shaken. And the question that cuts through it all is that somebody you see in the courtroom today. The moment Johnson points to Miss Lovely, it links her directly to the case, emotionally and legally. There's no room for ambiguity. If you were in the judge's seat, how much weight would you place on a parent's past behavior versus what's best for the child right now?
Okay, and who is the mother of that child? Okay, and just identify her. Okay, and is that somebody who you see here in the courtroom today? And how do you know Miss Lovely?
She's an white.
Okay, and you guys are obviously divorced then?
Yeah.
When was that divorce? When did that become effective?
2019.
Okay, and as such, out of that divorce proceeding, was there a custody arrangement that was entered into regarding your child?
Yes.
In September of 2022?
Yes.
Can you briefly tell us what the terms of that arrangement were?
Yes. We each had 50-50 custody.
joint custody. And then we did our exchanges on Fridays.
Okay. And so is that one parent would drop them off at school, the other parent would then pick them up?
Yes, we complete your week by dropping them off on Friday, and then the other parent would start their week picking them up.
Okay. So I want to fast forward to Thursday of I'm sorry, February of 2023. Did anything change regarding that arrangement, that custody arrangement?
Yes, that the first week of February, I would have had custody of my son. And I was contacted by.
This is where the timeline starts to unravel. Johnson's statement that he should have had custody the first week of February places a key stake in the ground, a clear point where the custody agreement allegedly broke. From this point forward, every day that passes becomes potential evidence of custodial interference. The defense may try to spin this as a misunderstanding or miscommunication, but Johnson is clear the agreement existed and he expected compliance. Not only that, CPS had already reached out and given a green light to resume normal exchanges. That approval adds legal credibility to his expectations. What's critical here is that Johnson doesn't just talk in generalities. He pins down specific days. That precision matters. When violations hinge on custody days, not just weeks, the details become the prosecution's sharpest tools. Viewers, do you think a single missed week should lead to criminal charges, or should this have stayed a civil dispute?
Investigating the claims that she had made against me. They turned out to be false. So I believe it was like the 6th, they contacted me and they said, we're going to go back to normal custody. We advised her to continue like you should be, dropping him off at school, and I would pick him up, et cetera. And that never happened.
Okay.
He was never returned.
So February 6th of 2023, I believe that was a Monday.
Monday or Tuesday.
Okay. You were supposed to have the child on what day? That Friday. So roughly the 3rd. I looked at a calendar earlier.
Yeah, I'd have to look at it.
Okay.
Well, hold on. I just want to make sure. On the 3rd would have been your pickup, the beginning of your custody.
Yes.
Okay, go ahead.
And then that should have terminated with you dropping the child off on the 10th.
Yeah, Friday.
Okay.
Whatever the Fridays were. Got it.
All right. And so then now turning to the 6th of February, CPS gives you the okay to resume your pickup. Do you have any interaction with the defendant regarding the child exchange on the 6th?
The moment Johnson says yes, we enter the danger zone, because from this point forward, the defendant's awareness and actions are now under the legal microscope. If they interacted on the 6th and she still didn't comply, that interaction becomes a central piece of evidence. Now remember, courts often give leeway for confusion, illness, even logistical problems. But once two parties speak directly and there's no action taken, things shift from misunderstanding to potential willful defiance. It's also important that this interaction happens after CPS gave clearance. That means the state said, go ahead, and the father made contact, expecting follow-through. Any failure to return the child now looks like a deliberate decision, and that's exactly what prosecutors love to highlight. Have you ever experienced a situation where someone agreed to something and then ghosted? What did you do next?
Yeah, she contacted me on our family wizard.
Okay.
Told me she was not returning.
Okay. Prior to February 6th, had you been observing her social media feeds?
Yes.
Okay. And did you have any concerns about what the defendant was going to do with herself and the child?
Objection, Your Honor, as to the relevance of what's on her, allegedly on her social media feed, certainly with regard to what he may have speculated he was worried about her doing.
Well, but that goes to his state of mind as to everything. I'll overrule the objection. I'll hear it.
Go ahead. Yeah, so had you been kind of monitoring her social media?
Yes, I was concerned that she was going to stay
Okay. With a specific destination?
New York, that's all I knew.
Okay. And so did you share those concerns that you had with the defendant at all?
Yes, I told her that would be a violation. We were required to provide an itinerary to front of work, and that never happened.
Okay.
I verified that with Sarah Mazer. She said they hadn't received an itinerary, and that what she provided wasn't appropriate.
Okay.
This moment is a bombshell. When the father says the defendant gave an inappropriate itinerary and CPS didn't accept it, we now have a serious credibility issue. It's not just about missed deadlines or unclear pickup times anymore. It's about trust. Why was the itinerary inappropriate? Was it missing details? Did it suggest a flight out of state? The script doesn't tell us, but you can bet the courtroom is reading between the lines. This isn't just poor planning. It suggests that the mother may have been evasive or even deceptive about her location. And if she was planning to remove the child from the state, or even just couldn't prove where they'd be, that's a major red flag in family court. Judges don't play around with custody orders. You want your week? Fine, but you better make it clear where that child will be every step of the way. Question for the audience: should a parent lose custody rights for not disclosing travel plans?
So on the 6th, obviously the child does not return to your care.
Right.
Okay. What happens then on the 7th?
I contacted and law enforcement referenced the issue. A order was filled out and sent to the judge by a friend of court to pick my son up and return him to me. That was signed by Judge O'Brien.
Okay. Did you anticipate that you were going to be able to pick up your child from school that day?
Yeah,
Okay. Did you reach out to the school at all?
I did, and they told me that he hadn't been brought that day.
Okay.
I think he said it was like mental health or something like that.
You obviously didn't excuse him. Okay. Okay. All right. The order, when you contacted friend of the court, were you able to receive a copy of the order from friend of the court?
I did.
Okay. I'm going to approach with what's been marked as people's proposed exhibit number 1. If I may, Your Honor.
Yes, you may.
All right, Mr. Johnson, that exhibit that I've handed you, you've had an opportunity to review that before testifying today?
Yes.
And is that something that you're familiar with?
Yes, this is the order that they sent to the judge. That she's
Okay.
trying to pick up.
Okay. And is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien at the 22nd Circuit Court?
Yeah.
Okay.
Got it.
And that's the order. What was that order informing what was supposed to happen with the child?
I believe, let me read it just to clarify. Says that she's supposed to return to me immediately and not leave the state of Michigan.
Okay. Your Honor, unless there's any objection or voir dire on the issue, I'm going to move to admit people's proposed exhibit number 1.
No objection for purposes of exam.
Exhibit 1 is admitted.
Did the court want to review that?
Yeah, I'll say.
Thank you.
Thank you. Standard order. Okay. Go
Thank
ahead.
you. So now turning your attention then, so that February 7th, that order gets signed. You said that you contacted police. What agency did you contact?
Now things shift into a new gear. Johnson isn't just frustrated, he's activating the system. Contacting the Northfield Township Police moves this from a custody complaint to a potential law enforcement matter. What's significant here is that Johnson doesn't just call a local officer. He's directed to a multi-jurisdictional task force. That tells us this isn't being brushed aside. Law enforcement is treating it as serious, possibly criminal. Notice the layered escalation. CPS gives the green light. Ren child isn't returned. Ren school confirms absence. Ren dad calls the cops. Ren multi-agency unit gets involved. By the time we get to Trooper Pizzelle or Pizza, as he jokingly corrects, the courtroom already knows this isn't your average custody disagreement. The paper trail and verbal testimony are forming a legal wall. Question for viewers: at what point does a custody miscommunication become criminal? Is it the missed handoff, or when you ignore a cop's warning?
contacted Northfield Township, and I believe it was a detective that called me back, and he called me back.
Okay.
I sent him that document that I had, by email. And then he basically said because of the multi-jurisdictional thing, that he was gonna forward it to the state police.
Okay. And as such, did you end up later that day speaking to Trooper Pitzel? Pitzel. It rolls off the tongue. Pitzel. Okay. All right. And where did you speak to him at? Where did he come to your house?
No,
Okay, you spoke to him over the phone. Did he? Well, you kind of explained the situation to him as best you could. Okay. All right. Moving forward to Friday the 10th, had you received custody of your child by the 10th?
No.
Okay. Then moving forward to the 13th, that Monday, February 13th, by that point in time, had you received custody of your child? Okay. And it's your understanding that pursuant to the order, the child was supposed to remain in your care until further order of the court. Okay. All right. So then tell me what happens on the 14th of February. Had you, on the 14th of February, so this is Tuesday, had you received custody of your child?
We're now days past when Johnson should have had his child, and the answer remains a chilling no. The longer this goes, the more serious it gets. Every day that passes turns a civil breach into a potential felony. At this point, the system had tried everything: court orders, law enforcement contact, and even follow-up attempts. And yet, no compliance. From a judge's standpoint, the inaction here speaks volumes. If a parent is confused, they seek clarity. If they're afraid, they ask for help. But silence, repeated absence, that reads as defiance. What's more, Johnson isn't passive. He's making calls, checking with the school, filing orders, contacting troopers. The burden is no longer on him. The pressure is now squarely on the defendant, and the case against her is stacking up like bricks. Viewers, be honest. If this were your child and the other parent just disappeared with them, how would you respond?
Okay. So what did you do, or what happened in terms of that custody arrangement?
And contacted front court and law enforcement and advised them that at that point she wasn't even in Michigan anymore.
I mentioned on her foundation as to where she was.
I can, if it,
Well, he is, as I understand his statement, whether it's true or not, that's what he's indicating. So there may not be foundation for what it is, and the court will give it whatever weight I give that statement, but I'm going to overrule the objection. Go ahead.
thank you. Go ahead. So I'm sorry, you reached out to front of the court. You gave them some information.
Yes,
What happened as a result of that information?
they submitted another order to the judge. And this was for her, this was terminating her parental rights, and she had until the 24th, it's an ultimatum that she had to return them to the front court by then. That was the latest, but it was to immediately do that.
The 24th of February.
Yes, sir.
Thank you. And if I may approach with people's proposed exhibit number 2. The 14th.
Yes, you may.
Thank you. Mr. Johnson, you've been handed what's been marked as people's proposed exhibit number 2. We just talked about the court order, the document in front of you. Do you recognize that item?
Yes,
Likewise, did you have an opportunity to view that before testifying in court today?
I have.
Okay. And is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien on the 14th of February of this year?
yes, it was.
Okay.
Now we're looking at the second formal order in this timeline. The first was already ignored, and now the court escalates with a follow-up on February 14th, reinforcing the directive, return the child or face serious consequences. Why is this important? Because when a court has to issue a second, more urgent order, it signals that the situation has deteriorated. The judge isn't merely nudging, he's drawing a legal line in the sand. The Valentine's Day order doesn't come with flowers, it comes with a legal ultimatum. Johnson confirms he's seen it, reviewed it, and recognizes its authority. At this point, the defense has fewer escape routes. Ignorance of the first order might be argued, but the second one, that's a hard sell. If the court gives you a second chance to comply and you still ignore it, should that guarantee jail time?
And unless there's any objection or voir dire on the issue, I'm going to move to admit People's Proposed Exhibit number 2.
No objection for exam purposes, Judge.
Exhibit 2 is admitted.
All right, so then this order gets signed without telling me what you spoke to. Had you been communicating back and forth with the trooper during this period of time? Okay.
He advised the contact.
Well, don't tell me what he told you. I just want to know if there was still that communication. Okay.
Keep me updated on the status of the.
And had you been communicating with the defendant at all, sending either via Family Wizard or otherwise?
No, I sent her a message stating that I was contacting the authorities. She didn't return my child.
Did she ever respond in any kind of way? Okay. All right. So then to finish this up, when was the next time you actually received custody of your child?
I called the school Wednesday or Thursday. It was like 16th, I think, that week. And they said he was there, that he had been dropped off. And so I told them that I would be there early, pick him up. And I had the order. I gave them a copy of that. And so they were aware that I had custody of him.
Okay.
Finally, resolution. After weeks of uncertainty, Johnson confirms that he did get his son back, but it's how he did it that's telling, not through mutual agreement, but by arming himself with legal documents and showing up early at school. This wasn't a peaceful handoff. It was a defensive retrieval. The school needed proof. Johnson had to assert his rights with paperwork in hand. That alone tells you how tense and broken the co-parenting situation had become. It also reinforces how powerful and necessary clear legal orders are. Without that copy, he might have been turned away again. Even more important, Johnson's patience. He waited. He followed procedure. He respected the system. That's going to play very well in front of a jury. Your take: should schools be required to double-check court orders before allowing custody handoffs?
All right, and that was February, you believe, 16th of 2003, Thursday. Okay. And again, at that point in time, to the best of your knowledge, between February, well, I guess 6th and February 24th. So this is after communicating with CPS I'm sorry, February 16th. It was the defendant that was the only barrier between you and having custody of your child?
Yeah.
Okay. There was no communication that he was missing or anything to that extent. And in fact, had you spoken to your son during that intervening period of time?
Not allowed to have a phone call with him, just the one.
Okay. You had one phone conversation with him? You recognize his voice? Okay. All right. And I guess, how old is your child? Okay. So he doesn't, he may, I guess, but does he have a phone? Okay. So when you spoke to him,
Yes.
how did you get in contact with him?
We are required to call each other's cell phone.
Okay.
This is a quiet but powerful detail. Despite everything going on, legal orders, police involvement, emotional tension, the court hears that Johnson still managed to speak to his son once. The catch? He had to go through the defendant's phone. Why does this matter? Because it proves she had access to communication and still didn't facilitate parenting time. That's not just negligence. It could be framed as intentional obstruction. Even more chilling is the implication. If Johnson didn't initiate that one call, would he have heard from his child at all? It also hints that the child may have been shielded from the situation, possibly unaware of the storm surrounding them. But shielding turns to gatekeeping quickly when one parent blocks access completely. How much communication should be required between parents during shared custody? Should courts enforce minimum contact rules?
On his cell phone.
Okay. And so you called the defendant's cell phone and you were able to speak to the son?
Yeah.
Okay. Thank you. Your Honor, with that, I don't have any other questions for this, witness.
All right. Before you begin cross-examination, I just want to clarify one thing. The first order, sir, that was signed on by Judge O'Brien on the 7th, there was an indication that the child was to be returned to you, that your understanding was that the child was supposed to be returned and remain in your custody.
Yeah.
As I'm reading this,
Go back to 50-50, our regular agreement.
okay,
I think
that's fair. And if I'm counting out the dates, had the child would not have been returned to you really until the 14th, right? If I've got it.
that week. 'Cause I was supposed to have him that first week of the 3rd.
Correct. So you would have the 3rd basically through the 9th.
Yeah.
Right? Then the defendant would have the 10th through the 13th. And then your next time would have been the 14th and beyond,
The 17th.
or the 7th.
Yeah. Whatever that Friday would have been.
Yes, the 17th and beyond, I guess.
Yeah.
So I guess, okay, so here's what I'm trying to figure out. I'm looking at this order, and I'll let you see it again, the order of February 7th. And it indicates that they're ordered to immediately return the minor child to defendant's father custody care and so on.
Now we have it in black and white. The February 7th order doesn't hedge, doesn't suggest, doesn't ask. It orders the child to be returned immediately. And Judge Simpson is laser focused on that word, immediately. This is critical. In family law, timing is everything. The longer a parent delays, the more it can appear intentional. And the more intentional it looks, the closer it drifts toward criminal interference. Here, the judge isn't leaving it up for interpretation. He's spelling it out so no one can claim confusion later. The order was clear. The instructions were direct. Any failure to act on it, especially for multiple days, starts to look like contempt. And the fact that the court is spending this much time clarifying the order shows just how seriously it's being taken. If a court order uses the word immediately, how much delay, if any, should be considered acceptable?
Had that order been effectuated on the 7th, you would have then had the child from the 7th to what, the 10th?
Yeah.
Okay. And that's what didn't happen. Okay.
I didn't get him on the 3rd. I didn't have him. He was never returned. I never got him that week at all.
Right.
Yeah.
So, but what I'm saying is the time, I don't know really what I'm saying. What I'm indicating is you didn't get the child on the 3rd. The order to return the child to you signed the 7th. But if everything were to go back, really, there's like 3 days from the time of the order that it didn't happen. I mean, from the time of these orders, right? 3 or 4 days. Okay. The week then of, oh, let me just stop there for a moment. Because one of the questions the prosecutor asked you then is, on that order, that the child was to remain in your custody. That's not quite correct. On the 7th, is that right?
I believe she's supposed to be returned to me so we can continue our parenting time.
Okay, so, okay, that's something different. That's what I'm trying to figure out. On the 7th, the judge is ordering that the child be returned to you as though this interruption had not occurred. And then it would go back to the normal schedule, right? So from the 10th to the 17th, the defendant would have had primary possession of the child at that point, not really custody, but possession.
Yeah.
Here's the legal fork in the road. Judge Simpson suggests a very reasonable interpretation that after the missed week, the custody schedule would reset and the defendant would then have her rightful week starting the 10th. This is exactly the kind of gray area that defense lawyers love to exploit, but Simpson is smarter than that. He's already thinking ahead. If that 7th order meant resume as normal, then yes, the mom would get her week. But if it meant restart from scratch, then maybe not. Either way, what matters most is what happened after the judge clarified everything. And by that point, the defendant had already crossed the line multiple times. Real talk. When orders are unclear, should a parent act conservatively and return the child, or hold on and ask questions later?
What interrupts that, though, is then the order of the 14th, which then says, and this may have, I just want to be clear on it because it may be what you were talking about, the 14th order. That order doesn't, as I'm reading it, isn't now referencing the parenting time. That order is saying this child goes to the father. That's it, until the court says otherwise. Is that your understanding?
Yes.
Okay. That- Pardon?
That's how friend court explained it to me as well.
I probably did a better job though, right?
You did.
Okay, thank you. All right, thank you. No, it's okay. All right. Cross-examination.
Judge, if I could just have a moment.
Yeah.
May I receive the exhibits?
Mr. Johnson, are you currently employed? How?
I work at Diablo Salsa.
You do what?
I work at Little Diablo Salsa in the morning.
This may seem like an offhand moment. El Diablo Salsa doesn't exactly scream legal drama, but don't dismiss it. The prosecution is subtly reinforcing that Corey Johnson is not a reckless or unstable individual. He's employed, cooperative, and trying to work through the system. Why does that matter? Because in custody disputes, credibility is currency. The more grounded one parent appears, the more the judge may lean in their favor, especially when the other parent is ignoring court orders. The defense might try to portray him as emotionally reactive or overreaching, but this moment showing he's working a normal job and not just sitting at home angry helps solidify his image as a reasonable, responsible father. Audience question: does a parent's employment or routine lifestyle influence how you judge their credibility in a custody battle?
Well, Diablo Salsa, were you previously employed in law enforcement? When were you employed in law enforcement?
In 19.
How long were you in law enforcement prior to that?
I guess I'm going to object to the relevance of the question.
What is the relevance?
Judge, if I'm allowed to understand his involvement with law enforcement, it might explain why he chose to involve law enforcement in this in order to deal with what is a civil matter.
I don't know. I'll let you go. I don't think it's gonna matter to the court, because if a child's withheld against a court order, I don't know that that's a civil matter, but I'll let you have your definition. Go for it.
How long, when did you start working in law enforcement? And where did you work?
The police department. I worked for Hamburg Township, Northfield Township, and shortly, a little short stay at like the Golden Stockbridge and reserve work.
Prior to the reserve work, you, Northfield, Hamburg, and Pinckney, you were working there as a police officer? Would you describe this, the child custody arrangement in the course of your divorce as contentious?
That one word somewhat speaks volumes. Johnson doesn't jump to blame. He doesn't say hostile, toxic, or dangerous. He downplays it, and that's exactly what makes him look stronger in court. Because when someone resists the urge to lash out, it suggests they're focused on facts, not vendettas. And for the judge, that matters. This is also strategic by the defense. They're trying to plant the idea that this whole case is just a messy co-parenting argument, not a criminal one. They want you to think, A, they've always fought, but the evidence says otherwise. Orders were given, and they were ignored. That's not contentious, that's contempt. What's your take? When does a bitter co-parenting situation cross the line into legal danger?
Somewhat, yeah.
And this all started when Ms. Lovely filed a Child Protective Services complaint against you, correct?
And what else?
This particular incident.
Yeah, she did.
When did that happen?
I believe it was beginning of February. Amanda Moore contacted me from CPS in Oakland County.
So early February, CPS contacted you, indicated that an investigation was being started. And you were told that it was based on allegations made by Ms. Lovely.
Yes.
And you said, you testified that investigation was closed.
Yes.
When did that happen?
I think that was the 6th.
And how were you made aware of that?
I spoke to Amanda Moore, the investigator.
On February 6th or February 7th, you said you contacted a friend of the court.
Yeah.
Did you also file an ex parte motion and that motion was denied, correct?
Now we enter the procedural maze. And this one matters. Johnson filed a motion to compel parenting time, and it got denied. The defense seizes on this to imply the court itself was unsure who was in the right. But that's misleading. Just because one motion was denied doesn't mean there wasn't another valid order in effect, and we know there was the February 7th directive that she ignored. The defense's game here is confusion, blur the timeline, suggest inconsistency, make it sound like Johnson kept pushing after being told no, but the facts say otherwise. After that denial, the court itself took over, issuing direct orders, not just responding to motions. There's a huge legal difference between a denied motion and an enforceable court mandate, and only one of those carries criminal consequences. Does one failed motion weaken a parent's credibility, or should the final order be all that counts?
Yes, because they authorized the other one that from the court.
But you filed a motion and that motion was denied.
Yes.
Okay.
An ex parte motion, what?
That was an ex parte motion to compel your parenting time, correct? Judge, I have no further questions.
I don't have any redirect.
All right, you may step down, thank you. Any additional witnesses for the people?
I'm gonna call the trooper. And
Sir, please come forward and be sworn.
Yes, name?
I am Trooper Dustin Peitzel. Do you want me to spell it?
Yes, okay.
It's P-I-T, Susan Charlie, yeah.
Why is that so hard, Mr. Emmons?
You just,
And I just noticed that when you called him to the stand, you
Yeah, use the last name. You just use
I
his
asked-
title. Okay, I'm just saying,
You're on to my
I was-
ways.
I was paying attention, but go ahead. You may inquire.
Thank you.
Trooper Pizzell, nicknamed Pizza, in this oddly casual courtroom moment takes the stand and things get real fast. His testimony is the bridge between civil dispute and criminal case. Why? Because when law enforcement gets involved, they're not there to babysit a parenting schedule. They're there to enforce orders. And that's exactly what he tried to do. Pizzell testifies that he spoke directly to the defendant, showed her the custody order, and made it crystal clear that she had 24 hours to return the child or face consequences. That verbal warning carries legal weight. It proves she knew the order existed. She didn't say, "I never saw it." She said, "I don't believe it." And that's a dangerous difference. Audience challenge: if a cop told you you're violating a court order, would you take your chances and ignore it?
Trooper Pizzell, thank you for being here today. I want to turn your attention. How long have you been employed with the Michigan State Police? Thank you. And were you employed in that capacity early February of 2023?
Yes.
Did you become involved in incident between a custody issue between Alante Lovely and Corey Johnston?
Yes.
Thank you. Who did you first, or how did you first get involved in this information? And again, I would respect it to the extent that you have to refer to the child, just refer to it as the child.
At first, I was dispatched to an assistant agency. I was from my dispatch notes, I was advised to contact Detective Buxton, I believe his name was.
Thank you. And I think that's Buxton.
That's correct. The Township Police Department. I contacted him and he advised me of the dispute that we're here for today.
Okay. We had some testimony earlier about their court order. As a result of that communication with the Detective Buxton, were you able to receive some kind of court order in some kind of way?
Yes, he forwarded the email to me and I was able to review and see the court order as well.
Okay. After speaking to the detective, based on the information that he gave you, you have a telephone conversation with Johnston?
Yes.
Okay. Did you get some fine information from him?
A little bit more information on what Detective Buxton was able to provide.
Now you have the information from the Northfield Township Police as well as from Mr. Johnston. What was your next step of your investigation to assist with this situation?
My next step was to make contact with Miss Lovely and I guess attempt to persuade her to comply with the court order.
Okay, and did you do that?
Yes, I did.
Where did you speak with Miss Lovely?
I spoke with her at her residence in South Line.
Okay. And for all intents and purposes, that's I think there's a small part of South Lyon that's in Washtenaw County, but her residence is in the Oakland part.
Correct. It is in Oakland.
Okay. And is the defendant, is that somebody who you see in the courtroom today?
Yes.
Just need you to point to her and tell us what she's wearing.
It's the female with a kind of white shirt with flowers on it.
Thank you.
Or kind of beige.
And for the record, Your Honor, the witnesses identified the defendant.
And record shows so reflect without objection.
And thank you. Did you have a conversation with the defendant?
Yes, I did.
And did you talk about the court order?
I discussed it with her. We talked through it together, yes.
Okay, and what was her response in regards to you showing her this order that she's supposed to return the child?
She advised me that she would not return the child.
This is the confession moment. The officer tells the courtroom, under oath, that Miss Lovely flat out refused to return the child. No confusion, no delay, just a clear "I won't." That's all the prosecution needs. The element of intent is now locked in. If she had said, "I'm not sure this is real," or "I need time," the defense might have wiggle room. But saying, "I will not return the child," that's willful defiance of a court order. It's also the moment when reasonable doubt starts to evaporate. Once a defendant admits to disobeying, even when warned of the consequences, the jury doesn't have to do much guesswork. This isn't negligence, it's choice. Would you call this parental protection or obstruction of justice?
Okay. When she advised that she wasn't going to return the child, what did you do?
I told her I would be in contact with her within 24 hours. And to confirm whether she returned or not returned the child.
Okay. Did you inform her of maybe some of the consequences of not returning the child?
Yes, I did. I informed her that if she failed to return the child within 24 hours, that charges would be sent up against her.
Okay. Did she in some way show some kind of acknowledgement that she understood what you were saying?
Yes.
Okay. So then, did you follow up with the parties at some point in time later?
Yes, on February 10th, I called Mr. Johnson again to confirm whether his son or whether the child had been, and he advised me he had not been returned.
Okay. And so based on the information that you got from Mr. Johnson, did you then speak to Miss Lovely again?
Yes.
And what did Miss Lovely tell you about that?
Miss Lovely told me that she once again did not return the child and that she questioned the validity of the court document that I provided her.
Okay. When she questioned the validity of the court document, did you offer to do anything for her?
I did, yes.
Okay. And what was that?
I offered to, I believe that was a Friday night, courts were closed. I told her, hey, I'll go down to the 22nd Circuit Court as well and confirm that this is indeed a valid document. To prove to her that yes, this is a valid document.
Okay. And did you do that? Did you follow up with the 22nd Circuit Court?
Yes.
Okay. Did you get some kind of confirmation about the validity of the document?
Yes, I had spoken to one of the clerks, I believe her name was Miss Thompson, and she confirmed that that document was signed on the 7th by the judge's name is spacing right on my mind here, but
Judge O'Brien?
Judge O'Brien, thank
Thank
you. And she confirmed that that was a valid document.
Okay. And did you then relay that information to Miss Lovely?
Yes, I did.
Okay. So you've now told her about it on the 7th, gave her to the 10th to comply, and then on the 13th, tell her that it's a real court order. What was her response to you in regards to that information?
Once again, she told me she was refusing to return the child, and after a brief few words, she hung up on me.
This one's chilling. Even after the officer verifies the court order, after going to the courthouse himself, she still refuses to return the child. And not only that, she goes silent. That's not just defiance, it's stonewalling. At this point, the officer isn't trying to arrest her. He's trying to give her an out. One last chance. But she doesn't budge. She ignores his warning, dismisses his verification, and closes the door on any cooperative outcome. From the court's perspective, this is the final straw. If there was any question about misunderstanding, confusion, or procedural delay, this shuts it down. She was told, she was shown, she refused. Case closed. Honest moment. Do you think this was an act of protection or pride? What's the line between defending your child and breaking the law?
Okay. Thank you. Your Honor, with that, I don't have any other questions for this witness.
Cross-examination.
Thank you, Judge. Trooper, in the 4.5 years that you've worked for the state police, is this a common thing, common part of your duties?
I'm sorry, what do you mean as in?
I guess is
Are you?
serving orders for child custody, is that a common part of your duties?
In my 4.5 years, this is the first time I've had to do it.
The only time you've ever had to do it is in this case.
Yes.
So it's unusual. And you indicated that you spoke, well, I guess let me circle back. You received the order from Detective Buxton, correct?
Yes.
And where did Detective Buxton get it from?
And he advised me that he received it from Mr. Johnson.
From Mr. Johnston.
Yes.
So Detective Buxton didn't get it directly from the court either,
Unless he actually,
to your knowledge.
to my knowledge.
Okay. So you then told, as you indicated, you met with Ms. Lovely and you told her about the order and she indicated that she had doubts about its authenticity, correct?
Yes.
And you testified already, but that she told you that a motion had to that effect had been denied, correct?
Yes.
Right. So she asked you to independently verify that that was accurate. And you agreed to do that.
Yes.
And you told her that you would do that.
Yes.
Okay. And then by the time you were able to do that was September 10th, correct?
To
To
Yeah.
verify the document was authentic.
the 13th, she didn't,
February, not September.
she requested on the 10th for me to verify the document, not on the 7th.
Okay, so you agreed to do it on the 10th
Correct.
and then you verified it on the 13th.
Correct. 10th was a Friday night, courts were closed.
Right.
The 13th would have been the earliest. That was Monday morning.
So she had indicated, when did she indicate to you that she was concerned about the veracity of the document?
On the 10th.
She didn't tell you that on the 7th?
I do believe she probably did indicate it on the 7th.
Okay.
I don't recall.
Okay, so things she told you on the 7th, she certainly told you about the CPS investigation on the 7th.
Yes, she did.
Okay. Judge, if I could just have a moment.
You can.
Did you ever attempt to independently verify that that order had been entered prior to February 10th?
No.
You didn't look into Odyssey or any other system?
Yes, I did.
You did?
Yes.
Okay, what did you do?
It's not really a system I'm familiar with,
Mhm.
so I attempted to look through the online court system to see if any of that documentation or through the family court system,
Mhm.
to see if that order had been posted within it, and I did not see it in it.
And when did you do that?
I don't recall which date I did that.
Would you agree that it was somewhere between the 7th and the 10th?
Yes.
So you were, between the 7th and the 10th, you looked and you weren't able to see that that order was entered either?
Correct.
Nothing further, Judge. Thank you.
Any redirect?
I just want to reiterate. Did she express some doubt over the veracity of it on 7th of February of the order that you presented to her?
Yes, she didn't think it was a real document.
Okay. And then she might have also expressed some doubt on it on the 10th.
Yes,
That caused you to follow up with the court on the 13th.
yes.
Okay. Thank you. I don't have anything.
All right, thanks, Trooper. Yes, sir. Any additional witnesses?
I don't have any other witnesses, Your Honor.
Any witnesses for the defense?
No, thank you, Your Honor.
All right,
Your Honor, at this point in time, I motion to bind the defendant over on the charges contained within the information, the one count.
respond.
Your Honor, I would object. First of all, it seems to me that based on the testimony, this entirely occurred in South Lyon. So I'm not really sure that there's jurisdiction. This appears to have, the child was in Oakland County the entire time. So I think there may be a question as far as venue. However, on the facts of the case, the testimony is relatively clear from the trooper that he showed her this order on the 7th. She indicated to him that she didn't think it was accurate. They both, I think, he independently attempted to look in Odyssey, couldn't find the order. There was an order, a motion that was made and denied, which was testified to by Mr. Johnston. So at the very least, it makes it clear, I think, that there's confusion over what order would be entered or what order would be accurate if there was, this motion was already denied on one motion and then entered on another. Additionally, Your Honor, when the officer presents this to her and she indicates that she doesn't believe it's accurate, he agrees to look into it. Just a reasonable person would interpret that the officer is considering that possibility and is looking into it. If the officer is looking in to determine whether or not the document is accurate or true, it's reasonable for a person not to follow it until they're told that it is.
Or that they go and determine that themselves.
And she hasn't testified that she attempted to do that yet. However, need to prove that she attempted to do that, and it wouldn't have done any good because the officer already indicated that order was not in the system yet.
Or that he couldn't find.
Or that he couldn't find it. But it does take time for those orders to appear. She couldn't independently verify it. By the 10th, that's now her parenting time. She hasn't received verification from the officer yet, who's indicated he's going to look into it. He does. She gets verification on the 13th, but that order does not change, and the court indicated that order does not change her parenting time. Now she's into her week. So the child stays with her until the 17th, and then the child would go back to the child's father on the 17th, according to the parenting time agreement. That's obviously changed by the February 14th order, but that's not really what we appear to be discussing here. The issue seems to be this time period from the 7th to the 10th. Because the order that issued on the 14th said she had until the 24th to return the child, and the child was taken by the father on the 16th. So we never got to the violation of that particular order. So based on all of that, Judge, based on what the officer told her and what the officer did and how it would imply to her the possibility that this order is potentially untrue or invalid, he couldn't independently verify couldn't tell her that it was accurate until her parenting time had started, I would ask the court to dismiss the charges in their entirety. If nothing else, perhaps it's the basis of a show cause that could have been handled in family court, but as far as a parental kidnapping, I don't think it rises to the level to criminal conduct when the officer himself agrees to take on the task of verifying the veracity of the document.
Response.
I would ask the court, I know the court's probably already aware of this. Anything that our arguments are not evidence, but anything that Mr. Overwater argued was that what she did, there was no testimony to that. So let's just focus on the evidence that we have. Take or retain for more than 24 hours the child with the intent to detain and conceal the child from the child's other parent. What do we have? On the 6th, CPS says that Mr. Johnson testified, CPS indicates that child custody is to resume as normal. At the 7th, he's supposed to pick the kid up from school. The child does not go to school that day. That prompts Mr. Johnson to then turn his investigation both to the police as well as friend of the court. He's able to get this order. He talks with the trooper. Trooper turns around, talks to mom. At that point in time, mom is on notice. She says, I'm not returning the child. I don't believe that's real. Fast forward to the 10th. He tells her, you have 24 hours to do this, or you could be looking at charges. She rolls those dice. She says, well, I'm throwing it. The 10th, nothing changes. Custody has not changed. Mr. Johnson testifies he has not received his kid, his child, in those intervening days. Trooper Pitzel goes back on the 10th, says, hey, what's the deal with this order? She says, I don't believe it's real. I'm not giving the kid back. He verifies it on the 13th at her request, verifies that it was in fact real. She says, I'm still not going to return the child. It is what it is. 24 hours she had to return the child or comply with the custody agreement. That order was entered on the 7th. She was made aware of it on the 7th. There's no testimony to suggest that there was anything else that was going on other than there was this order that she had to comply with, and she didn't comply with it between the 7th and the 10th. So for that, Your Honor, as the court knows, this is an order out of our circuit court that gives us court venue and jurisdiction. That's where the order arises out of. That's where the underlying custody agreement comes out of, this court, giving this court jurisdiction over this matter. Therefore, I would ask the court to bind the defendant over on the charges contained in the information.
There may be two bases for certainly venue and jurisdiction of this court. The one that's brought up by the prosecutor, so I can dispose of that. It's enforcing a Washtenaw County order. Also that the venue is stated on the complaint is Northfield Township. There's going to be the 1 mile, certainly, or any conduct that occurs within that. So the court does believe it has jurisdiction and the venue is proper here. As with respect to the elements of this offense and when it occurred, what a wonderful world we would have if defendants who were presented an order by a peace officer were able to say, I don't believe the order, and just not comply without doing their own checking, without doing their own, I guess, footwork on it. Certainly, officers may assist in that, but once presented with the order, it is the person who is subject to that order's obligation to follow it, check it, verify it, and make sure they're in compliance with it. This defendant didn't do that. She just said, I don't believe this order, and then left it to everybody else. What is also clear from the testimony is that the parental father knows that it's his time and he has that order. He follows all lawful means to obtain the order. The order gets served on the defendant. The defendant says she doesn't believe it. The trooper told her she had 24 hours to comply with the order. She didn't. The question then becomes, well, and that's going to be from the period really from the 8th, because of the 24-hour period, to the 10th, that she did not comply with the order. And that in and of itself constitutes that offense. I think it may be a question of fact for the jury as to what the February 17th order means in terms of it going back, because there are different interpretations. One interpretation of that order, on the face of that order, one interpretation is, if you've interfered with my custody, then I basically take your week. So I still do the off and on, but now the weeks are reversed. That's one way to interpret that order, because it's just week on, week off. The other way to interpret that order is we go back to the normal schedule. I don't know which way that order really reads on the face of it, but in either event, I mean, and that to me says that that's going to be a question of fact, because it may very well be that the defendant then interfered with what would become the child's father's week that would have previously been her week, because that week on didn't happen. So that's a reasonable interpretation in this court's mind, certainly, and having seen it before, of these orders. Under either analysis, and again, I'm here to decide whether or not there's probable cause to believe that a crime was committed, not as to whether or not she has complied with the order, nor to necessarily give an interpretation of that order. That's for other proceedings. Given all of that, the court does believe that the defendant has committed the offense of kidnapping, custodial interference, and that people have sustained their burden of showing that by probable cause, either, so that we're clear, either as to that period after being presented with the order and not complying within 24 hours, or in retaining the child if there were a switch of weeks for that following week. Under either one of those analyses, the people have sustained their burden. And therefore, the defendant is bound over to stand trial on this charge.
And there it is. Judge Simpson makes it official. This is going to trial. After weeks of missed custody exchanges, 2 ignored court orders, and a mountain of testimony from police and the child's father, the court has heard enough. This isn't just a parenting disagreement anymore. It's now a criminal case, bound over on charges of custodial interference. The judge made one thing clear: you don't get to decide which orders you believe. If a judge signs it, you follow it. Period. The turning point? Repeated refusals after being shown a valid court order, and after a state trooper gave a 24-hour warning. Miss Lovely gambled, and the legal system didn't blink. This case raises serious questions about co-parenting, enforcement, and how far is too far when trust breaks down. And now a jury will decide what comes next. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.